Y'all know, like me, I'm gonna keep it 100. I hope y'all ain't think that I wanted Big Meech to be a rat. So look, I just went through the whole thing again. All right. Big Meech ain't got no Rule 35. Big Meech ain't got no 5K1. Not on the docket. And the first time reduction. Shout out to his lawyer, Brittany Barnett. Shout out to Chad Marks. Chad Marks broke some of this down. I ain't gonna act like I broke it all down on my own. But I went to look this up on my own, and I investigated the last time reduction. The last time reduction, I wasn't sure how he got it, so I ain't want to speak on it. Now, Tammy Cohen's, the government informant, the DEA informant, paid DEA informant, that's another story. Him and his relationship with her and that, I ain't gonna get into that. But if you look up his last time reduction that he got, that's legit, and it's based on Federal Sentencing Amendment 821. Thousands of federal prisoners are about to get out on this. So if you see dudes who get out on this, I don't want nobody to think that they automatically hot. Who he tell on his time reduced? No, you don't got to tell. So check it out. I'm going to read it to you. But before I read it to you, because some people are going to be lost, it's a law that was passed that allows your points to be reduced. So if you was on probation, parole, in the system, and they gave you criminal history points, you could get something like 2 points back then for, I believe that's what Meech got. This law allows you to cut those 2 points off. Maybe TO somebody, what's up, home? It allows you to cut one of those points off, right? And that will put Big Meech 30-year sentence down to 200, I think he said 94 months or something like that. It put it under 30 years. He already had one-time reduction. And then he got this one. But check this out. They said something else in the feds. I'm telling you what I just looked him up on Pacer, bro. So, as of February 1st, 2024, eligible defendants awaiting sentencing and even those already serving sentences will get the benefit of a new amendment to the sentencing guidelines that will significantly reduce time spent in prison. On April 5, 2023, the U.S. Sentencing Commission voted to make two important amendments to the sentencing guidelines, namely Amendment 821, Part A and Part B. That's how Big Meech got out. The focus of this article is on Part B, which is the new Chapter 4 guideline under Section 4C 1.1, also known as the adjustment for 0-point offenders. 0-point offender adjustments. That allows for a 2-level decrease in the offense level for defendants who have 0 criminal history points. Sentencing in federal courts is an evolved process governed by federal sentencing guidelines that is often confusing to those not well versed in the nuances. Originally, the federal sentencing guidelines were mandatory until the Supreme Court's 2005 decision in United States v. Booker found that the guidelines violated the Sixth Amendment right to a trial by jury. A lot of dudes came home on this jump right here, right? In the aftermath of Booker, the guidelines became discretionary. And while federal judges are still required to calculate a defendant's sentencing guidelines before imposing sentences, judges are not bound to follow them. So that means that once upon a time when they had to give you 20, 30 years, now they can give you what they feel as though is correct within that statute. They don't have to go up there. So like back in the day when people's grandmothers got caught with crack and they had to give them 20 years and they didn't feel as though they deserved that. Now they can give them some other type of sentence that's within their discretion. So it kind of put the power back in the judge's hands. But in the aftermath of Booker, the guidelines became discretionary, and while federal judges are still required to calculate a defendant's sentencing guidelines before imposing sentences, judges are not bound to follow them. Rather, they must now treat the guidelines as just one of the many sentencing factors to be considered when sentencing. The federal sentencing guidelines determine sentences based on primarily 2 factors. 1, the conduct associated with the offense conduct which produces the offense level. And number 2, the defendant's criminal history. They provide 43 base levels of offense seriousness. Each time a crime is assigned a base offense level, which is the starting point for determining the seriousness of a particular offense. Most serious crimes have higher base offense levels. Then, specific offenses characteristics are added to the base offense level, which vary from offense to offense, but can increase or decrease the base offense level. So that is going to increase or decrease how much time you spend in prison. Ultimately, the sentence of an offender receives is based on these levels. Next, adjustments are added or subtracted. Adjustments are factors that can apply to any offense, such as the age of the victim, the offender's role in the offense, or whether the offender was a minimal participant or a leader in the offense. The guidelines also assign each offender to one of 6 criminal history categories based upon the extent of an offender's past misconduct, and the final offense level is determined by taking the base offense level and then adding or subtracting from any specific offense, characteristics and adjustments that apply. The point at which the final offense level and the criminal history of the offenders intersect on the Sentencing Commission's sentencing table determines the defendant's sentencing guideline range, or more importantly, the number of months in federal prison. For regular people, that means the years you're going to spend in federal prison. Amendment 21. That's what gave Big Meech this last time cut that sent him out the door. Amendment 21 is important because it provides for a decrease in offense levels for certain defendants without any criminal history points, or 0-point offenders. On April 5th, 2023, the Sentencing Commission announced that it had voted to promulgate amendments to the federal sentencing guidelines. Those amendments, which basically mean changes, those amendments more commonly referred to as Amendment 21, more commonly referred to as Amendment 821 or the 2023 Criminal History Amendment, were submitted to Congress on May 1st, 2023. Among other things, Amendment 821 revised guidelines provided to courts regarding people facing their first federal conviction. According to a study conducted by the Sentencing Commission, 0-point offenders have far less of a chance of recidivism than those with pre-existing criminal history points. Specifically, the Sentencing Commission sought to reduce recommended guideline ranges for offenders with 0 criminal history points under the guidelines, 0-point offenders. To do so, Subpart 1 of Part B of the amendment created a new chapter 4, guidelines at Section 4C1.1, amendment for certain 0-point offenders. Remember, 0-point offenders are dudes that ain't had no criminal history when they caught they beef. That provides a decrease of 2 levels. 2 levels is a lot in the feds. 2 levels from the offense level for offenders who did not receive any criminal history points and whose offense did not involve specified aggregated factors, like a person robbed a person, put him in the trunk. That's extra. This is impactful as many federal defendants have a criminal history category of 1 and will be eligible for this 2-level reduction, which will have significant impact at their sentencing, often lowering their sentencing range by many months, if not by years. So instead of me just saying, how did Meech get out, how did Meech get out, yeah, it looked real funny that he's dealing with a government informant, but Big Meech got out on Amendment 821, and this is legit. There's nothing hot about this. I looked this case up over and over again last night to make sure I ain't saying nothing wrong. Big Meech don't have no 5K1. Big Meech don't have no Rule 35. I'm not interested in saying, ooh, Big Meech is a rat. I never said he was a rat. I said something that's questionable, and I don't understand why he's dealing with a rat that got one of his buddies popped. But it's a whole lot more going on with Deion Gatlin case. What's up? What it do? But going back to Amendment 21, which is how Big Meech got out. His lawyer, Brittany Barnett, is a bad lawyer. Shout out to Miss Brittany Barnett. Got Tony Lewis out and a couple other people. So What is significant is that Amendment 821 is retroactive. What that means is dudes that was already in prison, like Big Meech, who's been in prison since 2005, was sitting on a specific sentence. The First Step Act, signed by Donald Trump, which got a lot of my buddies out, Tony Lewis, Anton White, few different people. That's how he got the first time reduction. The second one comes from this right here. I mean, I got to say that I've seen it. 2 levels seem small, but it takes so many years off the sentence. I mean, you got dudes from this 2 levels have gotten almost 40-something months off their sentence. So anyway, let me finish reading this one part. It makes it retroactive. That's how Meech and other dudes got it, right? So, meaning it is equally applicable to someone who will be sentenced tomorrow as it is to be an incarcerated offender who was sentenced many years ago. On August 24th, 2023, the Sentencing Commission allowed for delayed retroactive application of Amendment 821 relating to criminal history, which meaning that certain currently incarcerated individuals could be eligible for reduced sentences made effective beginning February 1st, 2024. So that's why I said, hold on, I don't want to say nothing about Big Meech yet. I got to go read this 2024 thing. It was in there. I didn't look it up until last night. All right. So when I looked it up, I said, oh, Big Meech got a time reduction for something that was filed in February, and it scared me. So I ain't want to speak on it yet. I said, hold on, bro. Before I speak on this, let me go read it. So I go read it, and I see that Amendment 821 is legit. So, being as though I questioned his integrity because he dealing with a paid government informant, a DEA informant, it made me question his integrity. But there's no 5K1 and there's no Rule 35. But let me finish giving you this. Generally, there are 2 kinds of inmates considered 0-point offenders. Big Meech is one of these. Those with no prior criminal convictions, and those whose prior convictions fall outside of Section 4A1. If an inmate passes this initial threshold, they must then meet 9 criteria to qualify for the reduction. This going specifically into whatever Big Meech and them filed. As indicated above, pursuant to this law, a court may only decrease the offense level determined under Chapter 2 and 3 by 2 levels, pursuant to Amendment 821. If the defendant did not receive any criminal history points from Chapter 4, Part A, and did not receive an adjustment under 3A 1.4, did not use violence or credible threats of violence in connection with the offense. Big Meech didn't have violence. Did not personally cause substantial financial hardship. Big Meech didn't. Did not possess, receive, purchase, transport, transfer, sell, or otherwise dispose of a firearm or other dangerous weapons. To my knowledge, I don't believe they had that either. Or induce another person to do so in connection with the offense. Did not receive an adjustment under 3A 1.1, hate crime motivation or vulnerable victims, or Section 3A 1.5, serious human rights offense. Big Meech don't got none of that. Did not receive an adjustment under 3B 1.1, aggregated verbal, and was not engaged in a continuing criminal enterprise. Well, that may be different, as defined by 21 U.S.C. 848. 848 is what he had, but that's something different. But I ain't gonna make that to be no big issue. But Big Meech had an 848. As well as if the offense did not result in death or serious bodily injury, was not a sex offense, and is not covered by Section 2H 1.1, offenses involving individual rights. For those individuals who would have qualified and have already been sentenced, there are additional practical questions to ask. Did the inmate receive a downward departure? That's the 5K1 boys. Or a variance at that original sentencing? If so, compare the original imposed sentence to the amended guideline range. If the sentence imposed is lower, the inmate likely does not qualify. If it is not lower, the inmate may qualify for a 2-level offense reduction. So pending. That means that if you was a rat and you already had a 5K1 or Rule 35, the government's so wicked. They say, see, the government don't like rats. The government say, look, if we already gave one of you rats a downward departure, don't you even ask for this. So that may lead to further proof that Big Meech ain't a rat. They specifically say if you already got a downward departure, which is what rats get, that you can't get this. In such a scenario, a motion for resentencing may be filed under 18 U.S.C. Section 3582C. That's what Brittany Barnett filed for Big Meech. To be clear, reductions are not guaranteed, and courts are required to also review the sentencing factors outlined in 18 U.S.C. Section 3553A. Everybody should know that to know this resentencing joints. Regarding timing, although the Sentencing Commission made it clear that, absent congressional intervention, eligible incarcerated individuals are able to ask courts to reduce their sentences beginning November 1st, 2023. That was yesterday. Those eligible incarcerated individuals are only eligible to have their sentences reduced beginning on February 1st, 2024. Brittany Barnett had his joint in ASAP. She was at the door at 6 a.m. saying, yo, let's get Big Meech out. So it appears that courts are authorized to conduct sentence reductions proceeding and enter orders under 18 U.S.C. 3582C. 2. As we speak, and this was written months ago. To be sure, Amendment 821 will not be a ceremonial drop in the bucket. Instead, it will have real consequences, as it has been estimated that this amendment will affect at least 7,272 incarcerated individuals. So Big Meech is just one of 7,200 people that was a beneficiary of this law. 821, Amendment 821. Individuals who will be eligible for a lower sentencing range with a possible sentence reduction of 17.6% on average. Now you do 85% in the feds. They saying that they're going to add another 17.6% off of the 85%. So then that technically means that Meech is not even all the way home. Meech is in a halfway house or something like that. Technically, he's still in custody. So for everybody that's saying, damn, myself included, saying that, damn, how Big Meech get out? He had one time cut, now he got another time cut. Yo, what's up with it? 8, if you're interested in it, the law is Amendment 821. Can't call Big Meech a rat.